Welcome to Vet Chalk, exposing how veterans get screwed. By Eric Lee Hughes, accredited veterans claims agent. The story of Philip E. Cushman, superhero to veterans. Previously on Vet Chalk, when Congress and the VSO deprived veterans of judicial review, it was a knife in the back. King VA could lie, cheat, steal, and make up evidence without accountability. Today we discuss how VA cheated, but the new judicial review held VA accountable. Philip Cushman was a Marine infantryman in Vietnam. When fortifying his bunker, a sandbag fell on him and damaged his spine. Mr. Cushman needed 4 surgeries. In 1974, Philip Cushman filed for VA disability. The Board of Veterans' Appeals granted him a 60% rating for his back after appealing. In 1977, he applied for total disability based on individual unemployability (TDIU). Again, he appealed to the Board of Veterans' Appeals. Then things got interesting. In April of 1980, the board denied Mr. Cushman's claim. The board said, the evidence fails to show the presence of symptomology which would preclude sedentary employment, claim denied. Mr. Cushman was confused. His doctor said his back is worse and must stop present type of work. Mr. Cushman knew what his doctor had said. He had a copy of the doctor note, but something was wrong. The board's copy of the very same doctor note had an additional statement. Someone altered the doctor's statement, adding, or at least Ben Stoop. Lift. The new phrase turned a grant of TU into a denial. King VA cheated. Mr. Cushman applied for Social Security disability and won. He then reapplied for TU and won. Then he learned about VA's lie. With his own unaltered copy of the document in hand, Mr. Cushman applied for revision of the original denial based on clear and unmistakable error. If he won, he was due a big payday. But despite the evidence, he lost. Mr. Cushman used the new judicial review his fellow Vietnam veterans fought hard for and appealed to the Court of Appeals for Veterans Claims. He lost, but that isn't the end of the story. So, Mr. Cushman appealed to the Federal Circuit Court of Appeals. He argued his Fifth Amendment right to due process was violated by VA. King VA argued that veterans don't have a property interest in benefits applied for. Mr. Cushman won. It took Mr. Cushman 32 years to get his benefits properly awarded. Today, Philip Cushman is a hero to veterans and attorneys alike. Remember King VA's dirty trick? All that old history line King VA tried to hide had a time bomb waiting for him. Congress passed an act making appropriations for the payment of invalid pensions of the United States for the fiscal year ending June 13, 1895, and for other purposes. 53 Congress, Session 2, Chapter 140, July 18, 1884. That ticking time bomb reads, with the report of such examining surgeons when filed in the pension office shall be open to the examination and inspection of the claimant or his attorney, under such reasonable rules and regulations as the Secretary to the Interior may provide. So according to that old law from the 1880s, you can get a copy of your camp exam and your entire file. But crybaby King VA ignored the law and kept denying veterans and their attorneys access to the evidence file. Then Attorney H.S. Berlin appealed to King VA's boss, the Secretary of the Interior. On August 26, 1898, crybaby King VA got his butt paddled. In Re. H.S. Berlin, 9 PD page 471 in 1898, Secretary Bliss ordered. The claimant is entitled to be present, or to be represented by an attorney throughout the examination, and to cross-examine witnesses if he desires. In other words, it is his right to hear or know every word of testimony in his case, whether favorable or unfavorable. No court in the land would deny him this privilege. It is a constitutional right which cannot be abridged. But, the paddling continued. Secretary Bliss closed his ruling by saying, I am led to the conclusion that the practice which prevails in your Bureau of denying to claimants or their authorized attorneys the right to examine the evidence obtained by special examination, except that contained in reports of special examiners relating to criminal charges and investigations, is unjust to claimants and unwarranted by law. It is therefore directed that all orders or instructions which have that effect shall be revoked. So what does this have to do with Philip Cushman? When Secretary Bliss ruled that claimants have a constitutional right to see the evidence, King VA's old boss made a very important finding: veterans have rights. Not only do veterans have rights, they have the very constitutional rights Cushman had to go to the Federal Circuit to win. King VA lied through his teeth to the court because he knew his argument against property rights in veterans' claims was groundless. Bottom line. Philip Cushman needlessly had to wait 32 years for his claim to get fixed because of King VA's dirty trick. What a dumpster fire. This concludes Chapter 1 of Vet Chalk. Exposing how veterans get screwed. Please like and subscribe.